But okay, so for anyone who hasn't heard about the 2020 bail reform law, just break that down exactly what it is and what role you played in it being passed, or what do you know about it?
Yeah, sure. So at the time the bail reform statute was initially passed, I was still a appellate defender, so I played no personal role in its passage, but it was a long effort of a lot of like community organizers and affected folks and their families in coalition with defenders and other nonprofit folks in the criminal legal system reform space. A years long effort to reform New York's really draconian bail statutes. And so a quick and dirty sort of rundown of what it did was it made it so that judges could not set bail on certain misdemeanor and nonviolent felony offenses at the outset. Prior to bail reform, we saw judges were setting bail on things like turnstile jumping or like stealing a bar of soap from Target. And the purpose of bail reform was to stop that practice of just setting bail on folks who were experiencing poverty and especially at amounts that they were never going to be able to pay. So that was the main thing that it did, was separate offenses into bail eligible and non-bail eligible offenses. The other thing that it did that was really important, even though this was part of the law from the very beginning, it wasn't really explicit and it wasn't really followed. This principle of bail being a means to secure somebody's return to court. It was inherently part of the law, but it wasn't spelled out as cleanly as the 2020 reforms did. So they made it explicit that the only reason you can set bail on someone if the crime is bail eligible is to ensure their return to court, not because you think they're dangerous, not because you think they're going to go out and, steal something else, and only to ensure their return to court. So even though that wasn't a substantive change in terms of what the law was supposed to have said previously, the fact that it was made explicit really hammered home that sort of latent principle that judges have been ignoring for a long time. And the statute also put in requirements about judges having to actually make a record. They can't just say, okay, I've listened to the arguments and I'm setting bail at X amount. They have to explain why they think the person's a risk of flight and why they think bail is necessary as opposed to some lesser restriction like supervised release or electronic monitoring or some kind of treatment program. So it was a really robust statute at the time. Obviously, there was a lot of debate and back and forth about, the discrepancy between bail eligible and non-bail eligible and who we're leaving out. And I think those were really important conversations to be had that were had. So it wasn't perfect even at the time it was passed, but it was better than what the law had been previously.
And I guess why is, I kind of understand why, but just for the audience, why is it important for the judges to state their reasoning? Why was that an important part of the statute?
Yeah, it was really important for judges to state their reasoning because that's the only way we can actually know whether they're following the law or not. So if the judge just says, okay, counsel, I heard what you said, I'm setting bail at, X amount, and doesn't say anything else about it, we don't know if they actually were considering risk of flight or not, or they're considering something else, or we don't know which factors in the statute that they relied on to come up with that amount. And so it really makes judges have to show their work so that if they are not following the law, there is a means for us, defense attorneys to challenge those decisions they're making.
And to basically rid it if we have to.
Yeah.
And Brian, what are you currently doing in terms of, what's your role as in decarceration unit?
When I started in the decarceration unit in 2019 before the law was implemented, right?
Okay.
And when I interviewed, I learned more about the work that the Decarceration Project was doing. And for someone like me that was involved in the criminal justice system, when I was going through the system, there wasn't people advocating. There wasn't wasn't this group, these coalitions that made these laws to make the bail process more equitable, right? So, I thought it was like incredible to me, and so now as when we transition into the law being implemented in 2020, what I do is, I assist the attorneys in every aspect, like obviously the trial attorneys in our office and the attorneys. I work with an attorney, her name is Danielle Welch, and I assist her. I assist the attorneys, like I help them with PSBs. I help them with anything dealing with bail, like either I
Can you say for our viewers what a PSB is?
Oh, it's partially secured surety bond. So it's just it's like, so the reason why the bail law was formed to end cash bail, right? Because they wanted to determine based on instead of based on like whether you're poor or not, they wanted to determine it based on public safety and individualized, like your risk assessment. So it goes based off whatever the statute says. So the judge has to make analysis based on that.